Noon, Madam President. Thank you for the recognition. I rise with a little bit of a different perspective on the legislation that's before us. I guess I would start by saying that this has been characterized by some to be an anti-business bill, and I would agree with that. But I would also say it's an anti-employee bill, and it is also anti-freedom and anti-fairness. And I guess my largest feelings of opposition come from a perception that this bill is a manifestation of the progressive wing of the modern Democratic Party's desire to use the legislature as a mechanism for collective bargaining. Instead of simply creating a playing field so that collective bargaining can exist and proceed naturally on a level playing field, we are passing more and more legislation that essentially takes the side of labor in our laws and unlevels that playing field. And I'm going to go through this bill, not in a lot of detail, but I think in a way that will make that quite clear. I want to just mention the title here for a moment, because anyone who's listened to me on this floor has heard me complain about the titles of bills before. And this one says, an act protecting employee freedom of speech and conscience. And I defy anyone to tell me how, because that's not what this bill does at all. I rewrote the title just jokingly sitting here while I was listening to the debate. I said, an act restricting employers to defend their own position and restricting employees from understanding the whole story and hearing from both sides when it comes to potentially forming an employee union. Because that's what this bill actually does. It doesn't protect an employee's freedom of speech. In fact, I don't know how the bill or the current law would infringe on an employee's freedom of speech. And I don't know how anyone protects someone else's conscience. That doesn't make any sense on its face. I want to state from the outset that everything that we do in this chamber matters. And I think sometimes my colleagues forget that. They forget the far-reaching implications of the laws that we pass in this state. Those laws matter. They will affect the environment that our constituents reside in. They will be impacted in some way, whether it's the cost of goods, the availability of employment, the overall well-being of the state of Connecticut that might affect the housing market, and on and on and on. So yes, on its face, it's an anti-business bill and will discourage employers from coming to Connecticut or staying here or expanding in this state, because it is yet another requirement placed on them to unlevel the playing field so that they are going to be faced with choices. And there will be other places for them to go that do not have this impediment. Just from my gut, the reason why I'm speaking today on this bill is because I believe it just violates basic notions of freedom and fairness. But let's just talk about the language of the bill first off. The first section is about the definitions that are affected. And I think a part of the problem with this legislation stems from those definitions. The very first definition that is referenced is something that is listed as quote-unquote political matters. And certainly that includes political candidates. And you might make a legitimate argument about whether or not employers should be force-feeding their employees about what political candidates they should or should not support. But this goes much farther than that. It includes language that says discussion about political parties, of course, but also proposals to change legislation or proposals to change regulation. And I would argue that that is a very, very broad definition, because certainly everyone in this room recognizes that politics affects every aspect of our lives. It'd be almost impossible not to come up with some sort of political connection to anything. We discuss bills in this chamber on every topic under the sun. Just look at any agenda on any day, and you see the number of things that we're touching. The environment, commerce, think of our legislative committees. We discuss and engage in conversation on every topic imaginable. And ultimately, all of those topics, even in the world around us, have political implications. This bill affects any employer. But I have questions about just what that means. What is the extent of this language? And I'm not going to actually ask any questions of the proponent of the bill, so I will let him off the hook early on that, because I will do this more or less rhetorically, because I just want the folks in this chamber to just think about these things. Like, the first questions I have is, what about employers that are involved specifically in politics? I know that there is a carve-out in this bill for certain types of religious institutions discussing religion, but there's no such carve-out. But there are many, many political organizations that have employees. It concerns me that this bill may, in fact, touch them. The Family Institute, which is kind of a religious and a political organization, but they discuss policy. Lobbyist organizations, our own political staffs, the Senate Republican staff, the Senate Democrat staff. Even people that are involved in business and industry that is polarized politically. Planned Parenthood, for instance. Think about the topics that these employers may want to talk about with their employees that might run afoul of this legislation. I guess what I'm saying is that this bill, even though we all know what the intent is, which is what I described in my revised title, which is to prevent employers from being able to present an alternative argument to organized labor, it tries to do it in the broadest possible terms, I think, to hide that fact in part, but I think it dangerously encroaches in so many other areas that it creates problems. And I think that's a haphazard approach, and I think it's somewhat dangerous. Let me just say that it's also going to affect an entire spectrum politically, because this, now that it's political matters and pertains to any change in legislation or regulation, it affects a lot of different things, and from left to right on the political spectrum. I'll just mention Disney for a second. You know, Disney's in the news a lot recently, and I'm not calling them out for any particular reason other than their upper management's politics are in the news. I don't know if they are having board meetings or sitting around and telling people what their policies should be, or that anyone that works for that company has to feel a certain way. But let's assume there's a mythical company that's doing that. I believe they should be able to. And I believe that if it's Disney or someone else and they say, we want people that share our political views and our, as Senator Kissel mentioned, woke view of the world, they should be able to do that. On the other side, you know, employers that want to have employees that have a free market view of the world or some other political ideology because they feel that's the best fit for their company and the vision that they have about how they're going to grow and be successful, they should be able to make that choice. And I'm fearful that when you start to say that the employer can no longer engage with their employees about that vision because it intersects with political ideology or the bills that we're discussing in this chamber or in Washington, D.C. or anywhere else, you've got a problem. I don't know if that's the intention here or not, but I think it's a problem. I also think that it is small-minded because I believe that the thing that has put us on the map of history in the world, the United States of America as the most prosperous and greatest place to live, is freedom in our interactions with one another. As our Declaration of Independence says, the pursuit of happiness. That freedom creates choice, which means that employees have the choice where to work. Employers have the choice who to hire for their companies. Consumers have the choice who to do business with. That choice is what creates innovation in the marketplace. It's what creates new ideas and new products. It's what creates the quality of life that we have. I went onto the NLRB website, and I was reading this short description about what someone's rights would be regarding union organizing, and I found something pretty interesting, which is that there are some restrictions. It says that an employer owns the job site, so your employer can really determine whether or not what you do while you're working in large degree. Working time is for work, I think it says right in there. But it does say that in non-work areas, such as parking lots or break rooms, unions can distribute literature and things like that. What I found was really fascinating, though, is it says that restrictions on an employee's ability to communicate with their coworkers cannot be discriminatory, which basically says that if you're an employer, you can say you can only talk about work when you're on the job, nothing else. But that's not something that happens in the real world. People wouldn't be happy in a job environment like that. So if an employer says, well, we certainly allow non-work related conversation. You want to talk about NASCAR or sports or the latest TV series on Netflix or whatever, as a day-to-day with your colleagues, that's fine. The problem with that is that also opens up the notion that your employees can discuss other things, include union organizing. I bring this up only because I feel like what this bill does is it unlevels the playing field. I heard Senator Kissel in particular mention that he felt that this bill was for the purpose of creating a fair playing field. But I believe this is absolutely the opposite of creating a fair playing field. And I believe that it undermines industry in a very significant way. People who are in business, people who are employers, need to be able to communicate with the people that work for them on these subjects. Imagine a hospital that is contemplating a merger. And that's something debated in the legislature often. Can that hospital no longer require their employees to come to a meeting to discuss the ramifications of that merger? What about nonprofits? Could a nonprofit agency that gets a grant from the state of Connecticut ask their employees to come to a meeting and say, hey, look, by the way, you should support this bill and you should write your legislator about it? Can they no longer do that? Or can they no longer compel someone to be aware of it? Think about every aspect of politics and how it intersects with our day-to-day lives and how it interferes in business. Maybe that's a result of the government being too big and having its hands in too many things. Something I talk about a lot in here. An insurance agency that's impacted by a new regulation wants to make their staff aware of it. Maybe a vape store, which might be forced out of business by legislation that is being discussed in this body. Or auto dealers concerned about electric vehicle legislation, or gun manufacturers concerned about lawsuits that are happening across the country that might put them out of business, or landlords or property management companies affected by legislation we pass in this bill. What about a company even simply switching health plans for their employees? A delivery company discussing green vehicles. Who knows? You could go on and on and on. But these are all political things. And they are all legitimate reasons why an employer might require their employees to show up for a meeting. My point is that everything, literally everything, will boil down to politics in some way. I wanted to also address the preemption conversation. I'm no attorney, and I really only have a surface understanding of the legal ramifications, but I did read the letters that were written by former Attorney General Jepsen and more recently by Attorney General Tong, and I heard the comments made by the distinguished chair of the Judiciary Committee. And I guess Attorney General Jepsen, back in the day, when he wrote a letter to then Minority Leader Len Fasano, he stated that he thought that this legislation would be unconstitutional. And he did so based on a few different grounds. The most important one is these two preemptions that exist in the law. One of them is called Garmin's, and the other one's called the machinist's preemption. But both of them essentially say that the NLRB basically has supremacy on the notion of this type of labor law, and if they don't cover it, then the states are not supposed to. And I understand the argument that was made was that, well, that's not really the case anymore for various reasons. Things are changing, blah, blah, blah. And I noticed that Attorney General Tong acknowledged those two preemptions. But there was a third thing mentioned in Jepsen's letter. And I want to remind everyone that Attorney General Jepsen was a partisan political figure elected as a Democrat as Attorney General. It's not like it was some anti-labor Republican Attorney General. I presume that he might not have personally even agreed with this policy. But this is what he thought the letter of the law said, and I commend him for writing it so clearly. The third thing he mentioned, which is omitted in all of these conversations, is the Taft-Hartley Act, which effectively was the federal government's response to this exact conversation about whether those preemptions existed or not. Because in Congress, after the NLRB was passed and those preemptions existed, there was still great debate about whether the states would be able to have these conversations and be able to pass these laws. So they had the debate in Congress, and the Taft-Hartley Act is the result. And it says, quote unquote, the expressing of any views, argument, or opinion, or the dissemination thereof, whether in written, printed, graphic, or visual form, shall not constitute or be evidence of an unfair labor practice under any of the provisions of this subchapter of the NLRA, if such expression contains no threat or reprisal or force or promise of benefit. I understand the last few words of that might be a characterization, but remember what we're talking about. The threat or reprisal of force has to do with only whether or not that information comes with that, not whether or not someone is complying with the employer's request. The point, I guess, is that while I'm not an expert on this, I do believe that people can disagree over whether or not the constitutionality of this language is in question. And I do have a concern that no matter what happens, it's very likely to be challenged, and it will be challenged at a cost to the state of Connecticut. Whether or not that is constitutional or not is a separate issue for me, though. My issue really is two things, I would say, about this bill. Two things. One is fairness, which I've alluded to a couple of times, and the other one is dishonesty. I mentioned dishonesty because I started by saying that the way we're approaching this legislation is dishonest. If the issue here is a desire to pass a bill prohibiting employers from having a meeting to discuss whether employers should organize, then pass that law. Put that bill here and let us debate it. But nobody wants to do that because that would be extremely controversial. Instead, we hide that in the midst of this political matters and religious matters language, which, as I pointed out, ends up touching on so many other aspects of life that it doesn't even make any sense. The other issue, as I said, is fairness. I mentioned a couple of minutes ago that I don't believe that employers trying to do business to make money, as was described by Senator Kissel earlier, is a bad thing. That's their purpose. That is their nature, in fact. And I believe with every fiber of me, my being, that that's a good thing. That it's not a selfish thing that people go into business to make money. The fact that people go into business to make money to better their own circumstances is possibly the most moral thing you can do, in my mind. Because it is that act, which some might describe as selfish, but really it's not selfishness that does damage to others. It is selfishness that does good to others, because what it does is it creates opportunity. The fact that I want to run a successful business and be more successful in life, and I want to have a nicer car and a better suit and a nicer home, every one of those activities and desires creates opportunity for other people and improves the quality of life for us all. That, in fact, is the notion of capitalism. That is why capitalism is so great. That is the engine for the quality of life that we have. The fact that I'm going to work hard to better my life means that I'm going to have income that I am going to use to spend on other things that allows people to make purchases, but creates jobs so that they will also have income. It also creates innovation because I want to do better than someone else. I want to put myself even farther ahead. It's what inspires us to greatness. It's what has inspired our country to become what it is. And every time we stifle that freedom, and make no mistake, when we pass laws in this chamber, almost every time, and certainly in this case, we are stifling freedom. We are canceling, by force, someone's rights. That's what drives me bananas. It's fairness, Rob. It's fairness. It's fairness. We're leveling the playing field. No, we're not. We are telling one side of the playing field, you are losing rights. I heard the word force used several times. I just want to clarify that no one is entitled to a job in America. No one. There's no guarantee that you have a job. There's no entitlement to a job. A job is a mutual agreement between adults. An employer and an employee, they get together, they figure out terms, and a job is created. And either side, except for some contractual obligations that they might enter into voluntarily also, are up to them. And if they don't like the terms on any given day, they can leave. So when people repeat in this chamber during this debate that somehow an employee is being forced to sit through a meeting, that is not true. Yes, it's not an easy thing to say, I got to go to a job I don't like, or I got to sit in a room and listen to something I don't want to hear. But it is your choice at the end of the day. You are not forced to sit there. You know, others might say, well, there's economic forces out there. You know, it's not so easy to go find another job. That's all true. But at the end of the day, if we live in a free society, there has to be choice. There has to be freedom, and yes, there are consequences. I'm reminded all the time by someone very close to me that you can stop. Rob, if you're going to keep talking about freedom, you got to talk about consequences. Because some people hear the word freedom and they think, oh, that's someone that just doesn't care about anyone else. That's not true. The people that I know that care about freedom, including myself, are more than happy to live with the consequences of our freedom. If we say people should be free to do what they want, then they should also be free to fail and succeed. And what is more American than that? There's also a notion behind this bill that Senator Kissel kind of alluded to, which is that somehow there is this antagonist relationship between employers and employees. Now, I don't think that's true either. Now, certainly it exists in some way in some places. But I know any place that I've ever been employed at, and the people that I have employed over the years, I've never had that relationship with any of them. Our relationship was based on the common knowledge that if we work together to move our cause of making money in business based on the product that we were selling or the service we were selling, that we would all benefit. That the employer would benefit and the employees would benefit as a result as well. That was the relationship that I'm used to. I believe that's the relationship that exists in more cases than not. And sometimes when we have particularly bills that come out of the labor committee in this building, they are all designed to perpetuate this notion that it's employers versus employees. Well, first off, it's not true. And second off, we represent employers and employees. It's not right to come in here and pass a law that says we're taking the side of one or the other. And that's what this law is, by the way. This proposed bill is a bill that puts force on one side. It puts a restriction on one side. It says that you are no longer able to do anything. That's the force in the bill. It's not employers forcing someone. It's the state forcing employers to comply with a restriction they would otherwise have in a free society. And why? I'll bring this back to the very first thing I said. Why? Because the people that want this bill don't like the idea of an employer being able to explain their side of the equation when there is a discussion about whether or not employees should organize. And that's why I said this is anti-employee also, because why don't they want them to know? I got nothing against organized labor or unions, and they should be able to do whatever they want. But the idea that they are the only ones that should be able to have a say, and we're going to restrict the employer's ability to present their argument to their employees on their time while they're paying them, is absurd to me. We are supposed to represent all our constituents, and that is not just the employees, it's not just union labor, it's everyone, including those employers who might have really good arguments to make. And I believe that we should leave that decision up to the employee with all of the available information to make the best choice for them personally. That is the freedom society that I want to live in, Madam President. So it's very simple here. If you vote yes for this bill, what you're doing is you're creating another anti-business regulation that imposes on an employee's ability to know the ramifications of organizing with a labor union or not by restricting that employer from being able to share their side of the story with them. I could talk for quite a while about this subject, Madam President, but I think I'm actually going to leave it there because really that is the ultimate decision that we're making. Do we need more laws for this? Do we need another law that is going to make Connecticut less attractive to business? Do we need another law that imposes on an employee's right to know? I don't think so. Thank you, Madam President.